Good morning, everyone. We're going to go ahead and get started with our community development meeting. Today's date is April 10, 2025. The time is 10 a.m. In attendance are Commissioners Eberline, Duncan, and Matari. I'm going to go ahead and call this meeting to order. We really don't have attendance outside of the county today, so there's no chairman's opening remarks. Are there any changes to the agenda?
Yes, Mr. Chairman, I would ask that we pull G5 only because Mr. Davison is ill and he knows the most about this subject matter.
Okay, no objection. We'll pull it. Poll for conflicts of interest. Do we have any conflicts up here? No? Nope. Okay. First item is our public hearing. This is for ORA 25-0002. It's an interim marine service businesses, and we have Director David Callahan to discuss it.
Thank you, Mr. Chairman. Good morning, everyone. I have Ben Tarbutton with me for any detailed questions you may have, but I can say that this item really fills a gap in our current development code, where we have never actually had a marine services section, and we should, because it's a highly important issue in the county for some businesses to be able to do dock repair and other things of that nature on Coeur d'Alene Lake and other lakes. And so to me, this really just fills a gap that should have been done probably many years ago. We have worked this up as an interim ordinance because that's more efficient, more effective, and we can circle back around as time allows through the comp plan update and do a final ordinance. But this, again, fills a useful need. In the actual packet before you, you'll see there's a new listing of marine services in the commercial zoning district, and then there's new performance standards section. There's an exception to our shoreline management section that's necessary so that you can actually have this use in the shoreline area. And then there's a new definition to just make it unambiguous what we are dealing with. I hope that sets the stage. Ben can fill in any gaps that there may be.
Do you have anything you wanted to add, Ben?
What I would add also is that staff has collaborated with John Condon, who you are familiar with. He's provided some valuable insight just on making sure that this is an appropriate use that have reasonable standards. And then we've also coordinated with different agencies too, to make sure that we've captured some of their concerns as well.
Okay.
And for the record, Mr. Condon's been doing this kind of work for some 40 years or more.
Does anyone have any questions up here?
Not necessarily a question, but a comment, a thought. Section 5, under the definition, new marine or marine service business, business operated for profit. So is there any time that a not-for-profit organization would be wanting to be included in that?
I'm thinking.
Okay.
Actually, I can think possibly if there was something related to like one of our summer camps on
It
the
wouldn't
lake.
hurt to open the door.
Yeah, I don't know if they actually operate any of those, but I think we could change that to say a for-profit or nonprofit business which provides.
Okay.
Yeah.
If the board were to so direct, we could do that.
I mean, would that constitute a marine service business if you were operating a camp on the?
That portion of it, you could have a marine service, business. You could still have a business within your nonprofit organization, whether it's a marine service business or something else. It just wouldn't be operated for profit. It would be operated for the benefit of the nonprofit organization.
So I think there's a usefulness to opening the window here, if you'll pardon the metaphor, so that we don't get hamstrung and not be able to allow other entities to do this. So my suggestion would be just allow Pat to have some discretion in rewording this, and we'll bring it back to you before we actually print it. Does that work?
Yeah.
Is the system broken?
It is, in the sense that we have had Mr. Condon doing this kind of work for lifetime, and we've never been able to actually recognize it under the code.
But is it not able to work?
It's not able to work in the sense that we don't have a way to acknowledge his business. For instance, in the commercial zone right now, near the Wolf Lodge area, that particular piece of land was rezoned decades ago. It presumably allows this use in that zone, but because it does not expressly say as much in the code, and we have no allowance for the site disturbance area to the shoreline management area to be encroached upon, we don't address the issue like this will. So that's how the current code is broken.
Right, and, the existing ones typically are non-conforming uses, but to establish a new one, in the unincorporated county, there really isn't a regulation that allows it right now, and this would.
So an easy way to think of this is it's been an oversight all this time that we are now fixing.
Okay.
Any other questions?
No, just do I have any agreement for the nonprofit language?
I mean, that's fine. I'd be hard pressed to think we would ever have a nonprofit marine services
Well,
business. but-
like if it's in conjunction with one of these summer camps that are nonprofit and they want to maintain their own, docks or pump out or whatever would be. So that was just my,
Yeah, I mean, usually a business is doing it for cash. Nonprofits are doing it for donations. And so it just, it really opens the door in some respects for someone to try to use a loophole to get something going too. But I don't have a problem with it because I really don't see it being an issue either way. But because we haven't dealt with it ever.
Right.
If we had dealt with it ever, I would say we probably need to think about this a lot more.
And this is an interim ordinance, so if within the coming year, if any issues arise, we can,
And that's the
fix
thing.
them in the permanent ordinance.
Right.
Yeah. So, I mean, I'm good with the direction. This is a public hearing, so we can get testimony if anyone wants to speak. We do have one gentleman who would like to speak. We will go ahead and take testimony for this ordinance. Would you like to speak, Mr. Condon?
if it's appropriate.
Just, you can go up to the microphone at the podium and just state your name for the record.
Good morning, my name is John Condon. I live in Hayden, Idaho. One thing that just came to mind, I think, which gives a better understanding of the necessity of this, is that this all kind of came to head some years ago when the county itself was in violation of their own ordinance when they were improving Carlin Bay. And I think, at least that's when I was first familiar with the issue. And I think when you really think deeper into it, the county itself, I think, could be considered a nonprofit, and yet they do work themselves on their own launches and waterfront properties. And I think over the years, that's been understood that this was a necessity, but it's always been in violation of their own ordinance. So it's been kind of kicked down the road a little bit, but it's been a work in progress, if you will. And that's why I think I really applaud you for taking some action now. And honestly, I didn't realize how complicated that simple idea was until you start trying to figure out the finer details. So I think the only thing one can do wrong today is not do something. We can always, work out the details, which there never seems to be any lack thereof. But I applaud you for taking this this initial step to kind of address this that's long overdue. And I just want to thank you for doing so.
Thank you. Anyone else who wants to speak for the ordinance? No one on Zoom. Is there anyone who would like to speak against the ordinance? Hearing nothing. I guess in this situation, because we're looking at making an amendment, would we want to end public testimony, or do we want to bring this back? Because I don't think...
It's not a material change.
I believe we can end public testimony and go into deliberations if that is the board's desire.
All right. Well, without objection, I'll take a motion.
I move that we end public testimony and enter into deliberations.
Aye.
Commissioner Eberline,
Aye.
Commissioner Duncan,
Aye.
Chair Matari.
Aye. Okay. I'm good with what you'd suggested. They can make the edit. And, it's an attempt to kind of fix a hole that's been in this situation for a long time.
I'm kind of in the mindset, if it ain't broke, don't fix it.
Yeah. And, I understand. And I think in this particular situation, it is a little bit broken because it forces all of these decisions to come before the board, if I understand it correctly. And it goes into a little bit of conflict with some existing ordinance, if I understand this correctly.
That's fair.
And so it really is about the board making these decisions without any real guidance. It's just, if we want to, we will. If we don't want to, we won't. And this is kind of creating an ordinance that says we are good with this kind of activity on our waterways up to a point. Is that correct?
Yes, Mr. Chairman, and also it takes the staff out of an interpretive position, because at the moment we're having to interpret that this use ought to be allowed in the commercial zone,
Yeah.
whereas now it's unambiguous that it is allowed and it's defined.
Mr. Callahan, could you give me an example?
That was the one I was trying to explain earlier, where Mr. Condon actually had a piece of land that is commercial, and we did a special notice for that, for a similar type of use, but we had to shoehorn it in because we had no regulations on the books.
It also,
How did you shoehorn it in?
As a commercial use.
one other thing too, it also allows the marine service business to operate in the 25-foot shoreline protections zone, whereas that is expressly prohibited right now. We've kind of ignored it when we've done improvements to existing county
Docks.
boat launches.
Right.
But technically, that was prohibited, and now it would be specifically permitted.
In this ordinance?
Yes.
Yes, sir.
Yes. Okay.
I might add too that the board recently heard a variance request, and that goes to the point of these matters coming before the board, because Stancraft actually went through the zone change process to change it to commercial, but they still had the conflict with the shoreline management area. And they requested a variance to the shoreline management area, which the board did approve. But that again creates this big process. If we can make this outright permitted under these parameters, then I think it's more efficient. It allows the use. It gives
And that variance would not have been required.
the variance would not have been required, and it just sets people up with a reasonable expectation of what they can do off the property if they decide to look
Right.
at this kind of an operation.
It's basically setting someone up for success as opposed to setting someone up for failure.
Thank you. That's a nice way to put it.
Have there been times in the past where the board said no on these requests?
Hadn't
That you can
actually
think
come
of?
up to my knowledge before.
Yeah, there's only two that I can recall in both. Well, the one variance request that was approved, and then the time where there was a zone change before the board, and then the staff found out that the
Zoning had
zoning
already
actually
been
had
done.
been, established as commercial.
It was a mapping error.
That was the Condon facility on Wolf Lodge Bay.
So this is basically cleaning up some loose ends, lightening up the load on staff so they don't have to work on these things. It's
Lightening up the load on people who conduct or would like to conduct these businesses.
Including our county parks and waterways.
Correct.
okay.
What effect has it had on parks and waterways?
They will now be able to operate inside this new code.
Okay, so how?
Yeah, it permits that use within the shoreline management area. That's the biggest way that they benefit. It expressly allows that.
And so what that means is that they don't have to go through this process.
Correct.
Because they've had to go through this process too, no different than a private entity submitting an application.
And it's an interim, so we'll take this up again within a year.
Yeah, so that might be a good time to readdress it and see if it's actually working or if we just put it back in the trash can.
So again, this is not restricting, this is giving more freedom.
I understand.
Okay.
I understand.
Okay. Are we ready for a motion or?
Unless anyone has anything else to say? Yes.
Okay. I move that we approve ORA 25-0002, the interim marine services business, amending section 5 definition to add not-for-profit.
Second.
Commissioner Eberline,
Aye.
Commissioner Duncan,
Aye.
Chair Matari.
Aye, motion carries. Next up are deliberations, item number 2, CUP 24-0011. And this is the Kootenai County Landfill Expansion. It's an action item, and we will start with Vlad Finkel.
Mr. Chairman,
Oh.
before Mr. Finkel speaks, I would just like to set the stage briefly that there was an unusual aspect to this project in which the tribe had problems within their own ranks where they lost a person at my level. They were unable to fill that position, and consequently, the staff underneath that position was not working in the usual efficient way. And they also had an emailing problem with their server where information we were sending to the tribe was not getting through. And so I say all that to set the stage to say that one of the tribe's staff raised issues very late in the review process about there possibly being historic conflicts with this landfill. We believe that was properly addressed 2 years ago when we first started looking into this, and the consultants for the landfill talked to the tribe about this. Somehow that all got missed by the tribal staff, but I believe for reasons I just shared with you. So I think we did everything we could possibly do to reach out to the tribe multiple times by email and by telephone. Ultimately, we got it squared away. Ultimately, we have everything in place as it should be. But it created this sort of weird public record that I wanted to set this record straight right now today.
Thank you. All right, Vlad.
Good morning, Commissioners. For the record, Vlad Finkel with Kootenai County. As you, we have a presentation that we prepared for you to review. Is that something you're interested in doing so, or would you like me to run through the basic facts for you guys to make a decision?
Commissioner Duncan, Eberline? You want to go through the presentation?
That's fine.
Okay.
If you wish.
Yep.
Okay. Sounds good. As you stated, this is a request case number CUP 240011, a public utility complex facility. Director Callahan stated that we have been in communication with the Solid Waste Department for the last couple of years. In fact, based on historical review of the records, we've been communicating with the department for the last 8 years. I believe the first meeting took place in 2017, where we discussed the need and the requirements for the expansion of the existing landfill. We have had several meetings, not just with the director, the former director, and the current director of the Solid Waste Department. We actually met with a number of different engineering consultants to go through the record because, as you can understand, it was quite complex. There were at least 2 different conditional use permits issued in the past that established the use back in 1989, as well as modified version of it that allowed the expansion in 1999. As all of you know, the subject property is located in the southwest quadrant of Kootenai County, specifically on the west side of Highway 95 and just north of Fighting Creek Road. The current proposal will be located strictly on the west side. In the past, there was a small parcel of approximately 8 acres that was to the east of the subject property and east of Highway 95 that was part of the original request. Since then, it's my understanding that Solid Waste had done a land swap, and there are recorded deeds that basically allowed them to acquire additional land on the west side of Highway 95 for the proposed expansion, and then turn over the land that was no longer necessary to a different property owner. The property in question will be approximately 490 acres, comprising 13 contiguous parcels of land. The zoning designation is rural for the most part, with the exception of one parcel in the south area of the proposed project area that is agricultural. The comp plan designation is country as well as scenic. And some of the basic history is in 1989, under conditional use permit C-687-89, the county approved a landfill on 435 acres, and the actual area for the fill itself was 40 acres. Then in 1999, another application was submitted, and it was approved in 2000 for the expansion of the cell areas, and then the facility was increased from 435 to 446 acres with additional 69 acres for landfilling. The current proposal is to have a lateral expansion of the existing landfill, and the primary purpose is to construct another cell, the south cell, and then expand, modify, and integrate the existing west cell with the newly proposed south cell. So the new filling area would be approximately 197 acres, and that is still under 50% of the entire project area for the facility as a whole, which would be 490 acres. Based on my communication and staff's communication with the Solid Waste Department, their current calculations state that the facility at its current condition would likely be at capacity in approximately 17 years in 2042. However, with the proposed expansion, they could extend that out for additional 10 years and give them an ability to have a total of an additional 9.2 million cubic yards of solid waste storage area. This is the site plan. As you can see, the south cell area is the area that's being proposed. With this expansion, it's quite large. There's the west cell that's also going to be modified and expanded and better integrate with the proposed expansion area. Most of the improvements are currently in this area of the property. These are some of the photos that we took on a site visit. Mr. Phillips was kind enough to do a walkthrough with us. Myself and Ben Tarbutton had conducted a site inspection last fall. They showed us the existing improvements on site, including the landfilling area, all the stormwater features, all the ponds, everything that was part of the current operations. And then we drove out to Fighting Creek Road and looked at the facility looking north. And we looked at, our primary concern was, is there any existing residential development in the area that could be somehow impacted visually or some other way? And we find that the topographical features of the site really isolate the proposed expansion area visually from being noticeable from the adjoining parcels to the south. We don't think there's going to be any impact from Highway 95 or north or the west side of the property, just because of the topographical features and the area where the existing improvements are and the proposed area of expansion. And in that regard, we just think that the site is well suited for the proposed expansion. Now, through the review process, we were advised that there were a number of wetlands that are in the area of proposed south cell expansion. We had communicated with Army Corps of Engineers, and they are on board with what's going on. They advised staff through recommendations that there would need to be a process that they would need to follow in order to encroach and impact the wetland areas as well as restore them. So that condition is part of the report that was prepared by staff and then expanded on by the hearing examiner. One of the things that Director Callahan brought up before I proceeded with my presentation is that there appear to be some level of perhaps miscommunication, which I think will be addressed by the Solid Waste Department. In 2021, the department, on behalf of their consultant, determined that there were some cultural areas within the surrounding area of the landfill, but none were on the actual landfill area or the south cell geographical area where they want to propose the landfilling expansion. Then subsequently, right before the hearing, this was literally the last day that the report was due to go out for review by the hearing examiner, we received a response that there, in fact, could be some cultural resources within the proposed scope of expansion. I have made numerous attempts to get further clarification and did not get any response to this day. I know that Director Callahan has communicated with the legal counsel for the tribe, and it appears that communication is back on board, and both our department and Solid Waste will be working jointly to address any concerns that the tribe has in this regard. Furthermore, the integrated species aspect of this review also had a determination that there would be no impacts to endangered species with the south cell expansion. It appears that none of the agencies that we solicited comments from, with the exception of the tribe, had really any concerns. We felt that the recommendations that they proposed could easily be addressed through the conditions of approval that we written in the staff report. One of the things that was really a positive aspect of this review is we as a department felt that there could be some level of opposition going forward with this process, because a landfill could be, even if it's an expansion, for the most part, people feel like that type of use could be a nuisance from an aesthetical standpoint, noise, smell, and so forth. We only got 2 comments in support. Very little public involvement. That was quite surprising, but I guess it's a much needed service that everybody understands we need to have. Otherwise, there would need to be another site looked at for this type of facility elsewhere in the county, or it would have to be sourced out to a different jurisdiction. So we find that we have a number of recommendations that we proposed in the report. I don't think I need to go through this level of detail. We just find that it's a necessity, and we support the request. The hearing examiner heard this matter on March 6th, and they subsequently recommended approval. One of the things that I did want to point out is there was some level of concern that was brought forward during that hearing, and the hearing examiner wanted to make sure that some of the parcels would be prohibited from being used in the future for the expansion of the landfilling area itself, not for the supporting infrastructure improvements such as buildings, roads, and stormwater features. And in condition 8.11, there is a list of AINs that are stated, and the hearing examiner was very clear that they want to make sure that those parcels are not utilized for landfilling purposes. If you want, I can read that condition out loud for the public. Otherwise, you have that in your record. And furthermore, we were compelled, Ben Tarbutt and I were compelled to not only impose the conditions of approval that were a necessity as part of the current review in 2025, but in going through the previous decisions from 89 and 99, while majority of those conditions were met with the physical improvements or annual reviews by jurisdictional, local, and state agencies, there are some conditions that should remain in effect because they're important and valid to this date. And we have listed them as conditions 812 through 816, stemming from the 99 decision, which incorporate the early conditions from the 89 decision. And that concludes my presentation, if you have any questions for me.
Thank you. Questions? No? Okay. Well, I guess it's deliberations. I'm good with it as laid out.
I think the conditions can mitigate any concerns.
Me too.
All right, well, I'll take a motion.
I move that we approve CUP 24-0011, Kootenai County landfill expansion with conditions.
Second.
Commissioner Eberline,
Aye.
Commissioner Duncan.
Aye.
Chair Matari.
Aye, motion carries. Thank you. Next up are some business items. Number 3, fee resolution discussion, and Director Callahan.
Thank you, Commissioners. As you know, we periodically update our fees, and it's that time of year to do so again. My thought is that since we had such a significant increase last time we updated fees, that we really rectified any sort of misgivings or places where we were in the past not sufficiently keeping up with cost. So in my view, the only thing needs to be done this year is whatever consumer price index or other economic indice the auditors or you may tell us is useful as a guide to increase fees for this year. But I would see that as minimal in the 2-3 or so % range, unless you think otherwise. That's where we are at the moment.
Comments, thoughts?
No, I mean, if CPI is over 5%, we just have to have a public hearing, right? So.
Yeah, it really just, do you have any thoughts on that, or?
Really?
No, I mean,
It's pretty, prices go up hither and yon, and it's pretty simple here.
yeah, I think we just want to make sure that our fees are reflective of the actual cost, so that we're not overcharging or undercharging.
Exactly.
And are we looking at starting this October 1?
Do you have an idea?
Somewhere, Christina Garland, for the record. We're typically introduce these around July, August. We implemented last year in August, so we would hope to implement them again in August. We just wanted a guidance prior to moving forward.
Anything else on this?
Well, do they have direction? Is it just straight CPI, or are we looking at
Well,
what you want to do and what CPI? Which,
I mean, I think the only issue we're going to have is if this board approves a step. And then that, so the auditor's office would really have to come up with, you know, their estimates.
We could certainly work with the auditor's office.
okay.
I mean, unless you have some sort of insight into future price increases on any of your,
That's beyond my ken.
yeah, okay. So I think you have direction.
Thank you.
Thank you.
All right, next up, item 4, areas of impact discussion, and Director Callahan again.
Commissioners, as you know, we're working with the cities to go from our current areas of city impact to what this new state law requires, area of impact. They eliminated the city language, the legislature, I mean. I won't opine on that. But my question and dialogue for you is, in the past, our ACIs, in particular the Hayden, Post Falls, Rathdrum ACI, had a provision in it where we had an exclusive tier, and in that tier, we didn't allow subdivisions unless they tied to city water and sewer services. And so that effectively prohibited subdivisions in that part of the ACI. And so the dialogue I wanted to have with you is, now that the state law says only county regulations apply, not cities, does it make sense, and to me it kind of does, to look at within the areas that the new AI map might allow the cities to expand, consider rezoning lands that are maybe rural or other zoning districts that have a higher density to the agricultural zoning district, so that it would be effectively the same as what we have today. Pat, did you want to add anything to that?
Well, there's several areas that are, or at least until recent annexations had been Zone X suburban. And I think that is particularly incompatible with areas of impact. Rural allows subdivisions of at least 5-acre lots. My understanding from past discussions with cities is they would prefer a minimum parcel size of at least 10 acres. The ag zoning would prohibit subdivisions altogether, or there could be like a rural 10 or an ag 10 or something, or ag 15, whatever you wanted to come up with, that could allow subdivisions, but at a density that would still allow for redevelopment once they're annexed into cities. There's a few options available as far as zoning goes within these areas of impact.
And are we specifically just talking about this one that the exclusive tier is on, or we're just talking about other ones that?
That's one example.
Okay.
I think Coeur d'Alene's current area of city impact has
Similar.
Yeah, provisions.
And so to answer your question, I'd like to have your thoughts so that when I talk with the city staff, city managers, and mayors, I can convey your view of how we ought to approach this.
As long as the property owner is all right with the downzoning, then I'm happy to hear those arguments.
Will it save the property owner money on taxes if they downzone? Probably not.
Possibly.
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 Negligible.
It's not generally a
It's
lot.
hard, it's hard to speculate, but it would seem that, you lose a development right that would have negatively affected property value.
Yeah. So, I mean, I agree. We don't want to downzone for the sake of it, but I like a model that has lower density in the long run. It helps keep our taxes lower in the long run. Commissioner Eberline?
We need to make sure that the property owner is taken care of and is to satisfactory conditions, because otherwise we've stolen the property from them.
Yeah, well, I don't think anyone wants to do anything without the property owner's
Yes.
permission.
And that's imperative.
So, at least from a downzoning perspective.
Yeah, I think, and I think that is, sounds like unanimous direction of the board.
That's all I need. Thank you.
Yes, okay, well, that concludes business, so 10:40, meeting adjourned. Thank you.
Thank you, Commissioner.